Ms. Hennigan.
Client's not present, Your Honor. He emailed me over the weekend and indicated that he has entered inpatient rehabilitation services at Sacred Heart in Richmond, Michigan. Since I received that email over the weekend.
Can you speak up just a little bit?
Yes, sorry. Since I received that email over the weekend, I have not had the opportunity to confirm, but I did email him back, tell him that he needs to appear for court regardless. Have not heard from him yet, but I did pass that information on to Ms. Smith this morning, and both of us have people trying to confirm that that's his location.
Okay, all right. Do you know, I mean, I would hope at this point he already has the Zoom information, but that would have been an option that you could have exercised as well.
Absolutely. I would expect so, and did send my response telling him that it would be the expectation of this court that he would make an appearance in some manner.
Perfect. Okay. All right, Ms. Smith, we'll look for any information you have on that probably as part of your regular testimony. Okay? Yes. So let's go then to Mr. McFarland.
Here, the minor child is doing well. She's meeting her developmental goals. Right now, she's at horse camp. So I would say normalcy is being met or even exceeded. There is some trepidation as she does not know her future as far as schooling and the future. And there is a request that there be some individual psychological counseling to address that. My father's not here to sign that permission slip, so I'd be asking the court to grant authority for the agency to sign her in for individual psychological counseling.
Thank you.
Foster mother was cutting in and out this morning. I was able to chat with her, but if she doesn't rejoin us, that's because there's an extra session.
Yes. Very good. All right. Testimony this morning, Ms. Evans.
Thank you, Your Honor. Ms. Smith can be sworn in. Thank you. Ms. Smith, can you please state how you are involved in this matter?
I'm the foster care worker from Catholic Charities.
And how long have you been the foster care worker?
Since April.
Okay. Did you provide a court report for today's hearing?
Yes, I did.
And it looks like your cover sheet indicates, in addition to the court report and case service plan, several attachments. Are there any updates or modifications that need to be made to your court report or those attachments?
No.
Okay. At this point in time, where's the child currently placed?
She is with a relative, maternal aunt.
And does that placement still serve in her best interest?
Yes, it does.
And do you believe that they are exercising the reasonably prudent parent standard?
Absolutely.
The LJL indicated that the child is in need of mental health counseling. Is that something you are aware of as well?
Yes, she attends group grief counseling through Ellie's Place out in Ann Arbor, but it was recommended that she have an individual counselor. So she, I believe, has an appointment on the 12th. So I have brought with me today, hoping to see Mr. Hall to get his signature on that. But she already does have an appointment set for, I believe, Wednesday.
And given that he is not with, he's not present today, would you like the court to order that the agency has the permission to sign that slip?
Yes.
At this time, how would you describe Mr. Hall's level of compliance with and benefit from the case service plan?
Very minimal. At the start of this reporting period, he did appear to be engaged in some services, or at least starting. However, throughout the last 90 days, it fizzled off, and I have not had any contact with him in a little over a month.
In your report, you indicate, or you have the fact that Lucas County is no longer going to be pressing charges as relates to that situation in which we filed this petition. In your opinion, does that have any bearing on this case?
As far as Ricky's engagement or,
Right, like anything that's been put in his case service plan, like does that in itself solve any of the barriers to reunification?
no.
At this time, what are those barriers to reunification?
Substance abuse, which was actually discovered later on in this case. That was not something for JH's removal. But Mr. Hall does have a significant substance abuse problem, as well as anger management, domestic violence. I'm unsure of his current living situation. I did visit his residence. However, I asked for a lease. He was unable to provide that to me. I recently spoke with the worker on the other case, and she had said that she was tipped off that Christina was now residing with Ricky. And I believe the residence that Ricky is staying in is his sister's. And to my knowledge, she was trying to get him to leave, but that wasn't the case. That's about it. I'm not sure if Mr. Hall is employed either. I haven't received any pay stubs since May.
And your report indicates that several referrals have been made on his behalf, correct?
Correct.
And in one of them, I believe it might have been the Love and Logic referral with Miss Moore. Has he reached out to you to get another referral to a different provider?
No, he hasn't. And originally I had referred him to a Love and Logic parenting class that was at Adrian's schools, I believe, and that one was free. He didn't utilize that. That's when the referral was made to Brene Moore. There was a conflict of interest that she realized after a couple sessions, so she had to discontinue services with him. At that time, I had reached out and found a teacher actually in Manchester who provides the classes. She can do them on Monday nights, meet in a community. She does charge $25 per class. The agency did talk about reimbursing Ricky or going half. So all of that information would be provided to Ricky should he contact us for a new provider, because I do know that it was specified in either it was JH's psychological or CTAC or it was his psychological, but it was specified that he complete the Love and Logic parenting class.
And then there's also the component of his portion of the CTAC, I believe.
Yes,
Has he
so
been able to complete that, or can you just give us a little update on that?
So the only portion that the parent has in a CTAC is the parent-child bonding assessment. So at the time, and it still is, his parenting time is suspended. So in order for that to happen, we weren't really sure how that could happen. And at an FTM that we had, it was also discussed that because the parenting time has been suspended for so long, that should not be the first meeting that JH and Mr. Hall have.
In your report, you indicate that you've encouraged Mr. Hall to maybe write his daughter a letter just to start that communication back up, and that he has not taken initiative. Do you know if there's been any updates to that?
To my knowledge, no. When I made my home visit, I believe in May, he had asked if he could write his daughter a letter. And I said yes, and then as long as it would be appropriate, I would either pass that on to her or I would give that to her counselor, and that would be something that they could discuss. I never received anything. And then we also had an FTM in June, and that was also discussed and recommended and encouraged by his attorney. But to date, no, I haven't received anything, and to my knowledge, I don't believe the caregiver has either.
And Ms. Hennigan had indicated that Mr. Hall is in inpatient rehab. Do you have any more information on that?
I do not have any updates on that. I contacted his substance abuse counselor. She's in a session right now. I tried to get a hold of her before today's hearing. She was able to confirm at least the date last time. I'm not sure if it was through, his Medicaid or if it came through with CMH, but she was able to at least confirm the last time he went. So she's checking on that for me, but I don't have information to confirm whether or not he's there.
At this time, your court report indicates that you are recommending a goal change for adoption. Can you
Correct.
please explain why the goal for unification is no longer appropriate for this child?
Well, this far, into the case already, Mr. Hall hasn't demonstrated any kind of progress or efforts towards reunification. It appears that, the last time that I had contact with him was informing him that Lucas County was not going to pursue criminal charges. And that date also is when a lot of his services ended. So it would appear that Mr. Hall believes if he's not being charged criminally, that, that there isn't a case. I assume that, so I had emailed him and explained that's not the case and that he still has a case service plan. A, B, and C needs to be completed, and he hasn't made any efforts to engage in really any services or efforts to maintain some kind of bond with his daughter.
And in the LJL's report, there's an indication that the child's also needing some finality. Do you have any information on that, or do you share the same opinion?
I would agree. During home visits, she's excited for the school year, but the caregiver is, hesitant to, engage in details of what next year will look like, or they have a vacation to go to Disney, around Christmas. And she's also hesitant to get her excited, for that. So Julia is very uneasy about permanency and long-term. She's in a very tough spot right now.
And at the last hearing, you testified to this element too, but what would be the risk of harm, physical or emotional, psychological, to the child if she were to have parenting time with Mr. Hall right now?
I think right now to start parenting time would be very confusing to JH. It's been a while. It's been 6-7 months since she has seen him. She's, I don't want to say moving on, but she is more concerned for his well-being than missing him as a parent. I think that Mr. Hall needs to demonstrate some significant, progress towards wanting to maintain a bond with her, or starting to bond with her again, as well as his sobriety, before we would recommend any kind of visitation. And is it your intentions to provide the child's new therapist that hopefully she'll be working with a copy of the documents relevant to this case, like the CTAC, dad psych eval, everything like that? Okay, wonderful. Thank you. Is there anything else you'd like to bring to the court's attention? No.
Thank you. I have no further questions, Your Honor, and would move to admit to the court report with the attachments.
You mentioned that there was a FTM about a month ago. And do you recall if counseling for JH was discussed at that time?
Yes.
Mr. Hall? And do you recall him saying that he would approve that counseling for her?
I believe so. He hasn't refuse really anything for his daughter as far as services go or authorizations.
I just wanted the court to have note of that. And then at that same meeting, did he sign any releases for you?
He did.
And what was that release for?
Sacred Heart.
And was it the same location that we believe he's at today?
Yes.
So with that release, you are able to at least make attempts to reach out to see if you can verify his participation there, correct?
Yes.
And then you talked about goal change for JH. And this case has been ongoing for about 6 or 7 months, correct?
Yes.
What would be the reason for making a goal change at this point in the case, considering that she is placed with a family member and we're not as far into the case as we might be in many other situations like this?
With this case, with Juliet, with JH, so uneasy about, permanency and questioning where she's going to be at, as well as, Mr. Hall's complete lack of engagement in services. I think that she needs permanency sooner than later. And with him, no parenting time, no visitations have occurred in 6 months. I feel like it's time for a goal change.
And just one other question, and if you do not have this information, please feel free to say that to me. You talked about the Ohio charges and that we did get information saying that there will not be any charges forthcoming from Ohio. Was that the reason, or were the allegations in Ohio the main reason for this case being opened?
Initially, yes.
And in that case, the children who were the alleged victims in that case, were they Mr. Hall's children?
No.
And did you know that at first?
I was not the worker at first. When I was given the case in April, I was included in an email that they had DNA testing scheduled for Mr. Hall and one other individual. And we had learned that Ricky did not have his DNA done, but the other gentleman did, and he was in fact the father. So I believe in April it was known that Mr. Hall was not the father.
So at this point then, it's
Not the father of,
the children who were the alleged victims in the Ohio crime. So at this point then, it's been confirmed in this case that JH is not a sibling to the children who were involved with those allegations. Great, thank you. No further questions now.
Mr. McFarland?
One question, the current placement for JH is willing to adopt if that need arises, is that correct?
Yes.
Nothing further.
All right, Ms. Smith, there was an order in January indicating that parenting time at the time of adjudication was on hold because we needed a professional recommendation considering the trauma of the child, the allegations in the report, and then the updates on services being provided to the professional as asked. Recommendations to be reviewed and may be implemented with the agreement of the guardian ad litem and parenting time is recommended. This court is only authorized to suspend parenting time if there's a significant risk of harm to the child. So I was looking for a professional recommendation to tell me whether or not there was a significant risk of harm to the child associated with parenting time, which was what the fear was at the time of the outset of the case. Since then, at the first review, the issue of parenting time was reviewed again, and parenting time was on hold until the CTAC interview was completed in hopes that the CTAC interviewer would be able to express whether or not there was a risk of harm associated with parenting time. According to your testimony today, he was not allowed access to any professional or to the CTAC interview to determine whether or not there was a risk of harm associated with parenting time. The suspension of parenting time, you are now saying, forms the basis for your request to change the goal. But this parenting time suspension has never been supported by a professional.
It was.
So help me understand it.
Yes, CTAC, it states, and I submitted, it would have been in the last court report, a letter from the Resiliency Center that states that they are in support of suspending parenting time as you're fragile at that time. So there should be an attachment, Julie.
From the April report? Because that's the only other time we've been.
Yes, it would have been in the court report from April.
Okay, so I will ask my clerk's office to bring that over, but that's pretty inconsistent with the findings from the last order, which indicate that the CTAC interview with the father was to inform the parenting time moving forward. So was there more happening after the last hearing then with the CTAC?
I'm not sure what the date was that, Julia had her CTAC and then we had requested a letter from the Resiliency Center. And that was in support of suspending the visits. And then the only thing that Mr. Hall wasn't able to engage in was the bonding assessment because parenting time was suspended.
Okay, so I'm looking at the exhibit list from the last time. I have the court report, the trauma screening, a letter, another letter, a speech and language evaluation, Mr. Hall's psychological evaluation. I don't have the CTAC interview as an exhibit from our last review in April. The CTAC confirmation appointment sheet was submitted in January through the trauma screening checklist, but I don't have the CTAC.
Your Honor,
Yes.
I have copies of it with her last report. We have to look at those, but
I'm sorry, I couldn't hear you.
I have copies of those from Ms. Smith's last report, and
You have a copy of the CTAC?
I do, Your Honor, and the letter, they're submitted as exhibits 4 and 5. The recommendation letter is exhibit 4, the CTAC itself is exhibit 5 on her cover sheet.
It's not what I received, so perhaps we should review the exhibits from today as well to make sure that we have what.
I also have those.
Yeah.
All right. There's no ROA, just a letter. And I noted also, well, while we're talking about that for a second, there was a reference in the court report to embezzlement charges through the county of Lenawee.
Yes.
Do you know what the status is on that?
I believe he has court, I think it is noted in my report. He has a hearing in front of Judge Shadler this month.
Okay.
I'm not sure on the date that.
Tomorrow.
Tomorrow.
The 11th.
Thank you. Were you able to secure a register of action on that one at all?
I was not.
Okay. All right, well, I will look through the exhibits from last time then. Are there any follow-up questions or clarification on that issue of parenting time that you wanted to run through with your client, Ms. Thomas?
No, Your Honor, I've reviewed the court report from last time. And as Ms. Hennigan indicated, it's a pretty I would consider lengthy letter from the Resiliency Center from Western Michigan University that indicates, as Ms. Smith testified, the fragility of the child and needing to process some of that. So I don't have any further questions on that point.
All right, thank you, and I appreciate the clarification. That obviously addresses the concern that I had. Okay. Any recross?
No, Your Honor, I'm sorry, go.
No, none.
Very good.
Just some follow-up to what Ms. Thomas said. I was present at the last team meeting, so I do know that my client did have opportunity to look at this last report and to discuss JHSC TAC and the recommendation. So I do know that he is aware of that recommendation, and her fragility was brought up. So we stipulate to those records being considered by the court.
Okay, thank you. All right, thank you for your testimony. You may return to your seat.
Your Honor, at this time, there's still a substantial risk of harm to return this child to Mr. Hall. If he's in inpatient treatment, that issue of resolving his substance abuse needs to be resolved. Additionally, the lack of the contact between Mr. Hall and his child, despite, the recommendations to write those letters and get that process started, is also really concerning. We would ask the court to order that the department agency have the ability to consent for that mental health treatment, as it it's indicated Mr. Hall would not object to that. I just don't think he's available to sign for it as immediately as is needed for this child. And with that being said, it would also be the hope that in her treatment, preparing her and laying some foundation to re-engage with Mr. Hall, should he be available for to do that. The risk of harm to the child is her emotional and psychological well-being at this time regarding parenting time. And given the uncertainty around her permanency and needing that finality, we would request that the parenting time remain suspended until further recommendation from her therapist. We would also ask this court to consider a goal change, although it is early in the case. This court did notice that last hearing, but indicated permanency for this child is imperative, and we would have an early permanency hearing. And given the lack of engagement in the case service plan and resolving those barriers to reunification, in addition to the child's need for permanency and finality, we would ask this court to change the goal to adoption so reasonable efforts can be made to achieve that goal. Otherwise, we would ask for another 90-day review to see if Mr. Hall will re-engage, and if the permanency goal can then be revisited at that time. Thank you.
Well, the court finds all interested parties were given notice for purposes of today's review hearing.
I do have a closing remark.
Oh, go ahead.
Thank you, Your Honor. Just because criminal charges are not being pursued in Lucas County does not mean that that is definitiveness for innocence. There could be many reasons, such as fragility in the witnesses, the age of the witnesses testifying, etc., Your Honor. I am glad if father is in some type of rehab right now, although I don't have any evidence of that. I think I would like to see the report from the psychologist, the individual psychologist for the minor child, as far as it's in her best interest to proceed with adoption. So I would support at least a dual goal at this point in time of adoption and reunification. Thank you.
Thank you. All right. So,
Yeah, may I ask my closing statement?
sorry, go ahead.
It's okay, I apologize.
I'm looking for the CTAC event, which I found.
It's okay, it's Monday morning. First and foremost, I would say that, as I have indicated here today, I know that Mr. Hall's had the opportunity to review this information and throughout this case has not refused to sign any type of release that may be helpful to his daughter. So I'm not going to place any objection on the record on his behalf with regard to the court ordering or granting the request of DHS for JH to get counseling. However, with regard to the request to change the permanency goal, I would submit to the court that it is early on in this case to make such a decision that while he has not, Mr. Hall's not had time to spend with his, or not had the opportunity to spend with his daughter at this time, it appears that he may be taking steps to make improvements and make progress in this case. And if he is in fact enrolled with Sacred Heart, doing inpatient, that was part of the recommendation from his psychological evaluation. So that would indicate that he is trying to take steps to move forward with what's required in his case plan. That being said, we're all very aware that a sober parent is much different than a parent who is in an active addiction, and that given that Mr. Hall may complete this treatment, in 90 days, we may see a completely different parent appear before this court. So I would ask that the court set aside the consideration of a goal change today and review that in 90 days so we can have the opportunity to see if Mr. Hall indeed intends to continue making progress with his case plan, and so that perhaps JH can get involved in some counseling and the guardian ad litem can have the opportunity to review that counselor's perspective on what her needs are and what's in her best interest. Thank you.
Anything else before I make the findings? Okay. Court finds all interested parties were given notice for purposes of today's review hearing. I have located and reviewed the CTAC recommendation and the letter from last time. Thank you, Ms. Smith, for your patience on that point. So it does support, as was reviewed on the record, that there was a finding or a recommendation made that the child be given time to engage in therapeutic intervention in order to make sense of her unpredictable past, as well as the death of her mother. And a visitation at the time of the letter, which was February 13th, 2023, would lead to further behavioral and emotional difficulties for Julia. Accompanying the letter was the CTAC evaluation, which, according to Ms. Smith, the interaction between the child and the parent at the period of time when it was to be decided whether or not he should engage in that, it was thought that essentially that the risk would be too high to allow her to do that to her mental health. Am I understanding that correctly, Ms. Smith? Yes. It is of some concern that we don't have her in an individual counselor up until this point because of these particular recommendations that she needed time to engage in therapeutic intervention. I obviously have some concerns that perhaps visitation has, or the lack of visitation has been somewhat contributed to by the lack of that particular service or assessment on that point. But I do see that we do have some clear indications, at least as of February, that that would have been a risk to the child. Further supporting that is unfortunately the drop-off engagement in services and communication between Mr. Hall and the caseworker. He decided not to write any letters or engage with his daughter in other ways, that he could have potentially tried to rescue that bond that he may have had with his child. I don't have any information about the bond, what the bond looks like, other than the information that was in the original petition, as well as some of the remarks that were made by the professionals that briefly interviewed the child at the outset of the case. So I do see that there are some holes as it relates to some of the things that I have to look at, which would be the bond, for example, between the child and the parent. So I look forward to a letter from the child's individual counselor on that point. Perhaps we could offer Mr. Hall the opportunity to talk with that counselor as well to see if she or he thinks that engagement between or communication between the two of them would be appropriate or useful. And again, whether or not it poses a risk of harm to the child. All right. I do find reasonable efforts towards the goal of reunification are being made by Ms. Smith, and that Mr. McFarland is in satisfaction of his obligations as guardian ad litem, so thank you for that. Clearly, Mr. Hall is continuing to struggle with substances and has been engaged in intermittently, at best, with his services. He has showed up for some of them, so I want to give him credit for that. He has been attending on and off some of his anger management, although he's left Ms. Palmer with the impression that he doesn't need that, so we'll need him to fix that impression, Ms. Hannigan, between now and when we come back, if he would like to. And to also engage in some of the parenting time education, although, you know, having a roadblock of Ms. Moore discovering there was a conflict doesn't help, because then we've got to start over with a new provider. So he's had some hiccups, which can be very discouraging for a parent in this situation. Not being able to see a child. We know that there's a lot of information out there that supports that the more visitation there is there, the more successful a parent is with reunification. So on balance, I'm going to do a dual goal of adoption and reunification. I recognize on the other side of this that the child has some mental health diagnoses. She's been diagnosed with ADHD. She's had some work to do in getting to where she's meeting with her peers on an educational level, and she's got not only the ADHD, but also the dyslexia, that she's in an IE, she's got some IE services for that. I want to take a moment to thank our foster care placement because of all of the effort that's gone into making sure that she attended her physical therapy to correct a physical diagnosis with her walking, and the nutritionalist that was in place. So she's been through a lot and she's working very well. She's doing well in her placement. She does need permanency and stability. But the best resolution in these matters is when we can actually get a parent to engage and work towards at least building a relationship. I'm not saying that this child may not be looking for permanency by way of adoption in another home in the future, but I would like to see if her father is able to do that at all before we move forward, considering some of the hiccups that he's had. So a regular 90-day review period would be October 10th. But what I will do is set an earlier review to give him an opportunity to show that he's been in rehab and to show that he would be willing to engage in services. And we'll look at the goal again. On September 5th at 9. And I will authorize the individual counseling for the child in today's court order so that she's able to do that. Between now and when we come back, September 5th at 9 a.m., the child will remain where she's placed. Again, she's doing well there, which I appreciate. Also, Mr. Hall is clearly, hopefully, in rehabilitation and working on some of his issues and is not able to take the child into his care. He's not appeared for us today, unfortunately. He will be required to be here next time as well. That will be in the order, whether that be by Zoom or in person. But there is a significant risk of harm associated with returning this child to the care of her father, considering the fact that he's not been able to embrace his parenting skills, education, his substance abuse, disorder treatment, or his anger management in a significant way. And those are all the outstanding issues that were in place at the time the petition was filed. So, unless there's any questions, that's all for today, and we'll have another review, accelerated review and permanency planning hearing on September 5th at 9.